This is WAAY 31 Law Call.
Good evening, I'm Sharon Dovey. Welcome to WAAY 31 Law Call. Tonight we're talking about grandpa in the law. We're talking about things like estate planning, wills, but we're also talking about nursing homes and what to do if a family member of yours is in a nursing home, is injured in a nursing home. A lot of great people working in nursing homes taking care of our elderly. But there can be problems, and you need to know the outcome of the contracts law you may have entered into, whether you would get a trial, what a trial would be like, what the outcomes are, whether they have to have insurance, so many things. Call in your questions about grandpa in the law, the 31 Law Call number 256-536-0077. You can also email any questions. You can email any day of the week, any legal topic. You send it to lawcall@waaytv.com, and when we get to a show that's on point, we pull some out. We'll have some of your questions tonight from email questions. Michael Timberlake's here from Timberlake, League & Brooks. Good to have you here.
Great to be here.
So we're going to talk about grandpa in the law. You guys wind up doing a lot of cases with nursing home negligence and things like that.
Yeah, I mean, it kind of dovetails in between, we're talking about people that, what do you need to do as you grow older? What the requirements are, do you need a will? Do you need a power of attorney? Who that person needs to be?
Yeah.
What is my health insurance going to pay for? What is Medicare going to pay for? What, do I qualify for Medicaid? Those are the kind of things we're going to talk about. Our firm specifically deals with when bad thing happens, typically in assisted living facilities or long-term care facilities, nursing homes, those type of things. Those are the kind of things we deal with on a regular basis.
So call in. Until we get to your questions tonight, we've got some video for you. We like to give you make the law call. We pulled something off of YouTube. This lady comes up to a glass. Look at this.
Ouch.
She's just trying to open the door at a business, and you know how heavy those things are. So it seems like this ought to be an open and shut case, but premises liability, right? If she's coming to a store, you expect at least the facilities to be safe enough, and she gets trapped under there. She winds up being okay, but something like this, that's really scary.
Yeah, it is, and it's kind of one of those situations. It's like, who do you look for in this situation? First, we would look at the premises owner, the people that maintain the premises, and when you invite somebody in to your business to do transactions or whatever, you're basically saying this is a safe environment, please come in. And if it's not, then that can be a problem like this was. But the business themselves, they have to have some kind of notice of a problem. But and a lot of times we look at, okay, well, what was the maintenance that was done on this? Was this, something was installed 50 years ago and they didn't do anything with it? What happened from there? We, recently in a, really case that's about to go to trial, looking at a situation where the premises owner called a maintenance company, and they came in and fixed a problem within days of the time that our person got hurt. So we're really kind of in a battle between, is it the premises owner or is it the people that they called to come in and fix the door? So, there are a lot of issues you can deal with this year.
Interesting. So tonight we're going to focus on your calls and questions about grandpa in the law, things like estate planning, nursing home care. We've got with us Clint on the line with a question from Madison. Hi, Clint. Thanks for calling. What's your question tonight?
Yeah, I got a question. My mother recently passed away, and my father now, he's going through dementia.
I'm sorry.
He can't remember anything. How do we protect his estate from being taken away by the courts or by any of my greedy sisters?
Is it too late for him to do wills and things like that, or do these kind of documents? What can he do?
Well, I mean, basically, just because somebody's been diagnosed with dementia doesn't mean that they're incapable of, having the intent to sign a power of attorney or sign a will or some kind of, designate some kind of beneficiary of their estate. So really, it's one of those situations where you need to figure out what the property is that we're dealing with here, and figure out how to, protect it, from himself. If he decides to give it to somebody, the grandkid that's, been arrested overseas or whatever, those kind of scams go on. And then, you want to make sure that somebody else that has, that's over it, has his best interest at heart. So you can have a power of attorney assigned for over him, or you can have some designated beneficiaries through his estate, so he doesn't even have to have a will. Those are, kind of things you need to talk to an attorney about, planning going forward. The sooner the better.
Yeah, because if he gets to a point that he's not lucid, that's a
Exactly.
problem, right? What's the problem with that?
Well, I mean, in order to have a valid power of attorney or a valid will, you have to understand what you're doing at that time. It doesn't mean that you're 100% lucid all the time.
Maybe none of us are.
Yeah, I mean, that's a good point. But a lot of times what we deal with is, okay, somebody's slipping a little bit, but they still understand what they're doing. That is still someone that's perfectly, able to create a will, and you have witnesses to make sure that everybody understands what's going on there. But if somebody gets to the point where they don't know who they are on a daily basis and don't know which way's up, that's a lot more of a problem. And then you're looking at, having them adjudicated incompetent by a court, having a guardian appointed, and that gets very, very messy.
So he was worried about the state getting the property, right? So if Dad wound up going to a nursing home,
right,
they've got to pay for that. What are
Sure.
nursing homes costing these days?
Well, I
per
mean,
month?
if you're in a situation where you need long-term care, the biggest thing that we can tell you is that, Medicare, which is the health insurance that you're entitled to when you retire if you qualify, does not pay for long-term care. It will not pay for you to be in a nursing home for any significant amount of time. It will pay typically for a 21-day stay after a hospitalization for rehabilitation. But if you need to be in a nursing home or long-term care for an extended period of time, they're not going to pay for that. And so you're either going to have to pay for that out of your own bank account, or you're going to have to be someone that qualifies for need-based benefits such as Medicaid, Medicaid, that would, require you to have basically nothing in your bank account. So those are all things you need to look at.
Okay, so if he's saying if his dad needed nursing home care,
Right.
then they're going to have to pay for that. So it's either going to come out of son's monies or come out of dad's money.
Precisely.
Okay. Is it too late to be? There are some estate planning things you can do ahead of time, right? To move some of those things around.
Yeah, absolutely. Basically, in the situation where you're talking about trying to anticipate the fact that somebody might need to be and need long-term care, the first thing you look at is some type of long-term care insurance that you could pay for, pay a monthly premium, and then in the event that you go into long-term care, it pays for the care. That's the best thing that you could do. Otherwise, you're just trying to plan for the fact that you may be on Medicaid, which Medicaid says, look, if you've got more than $2,000 in income in a month, you're not going to qualify. They can overlook some assets like your house or your homestead, but they'll come back and get those when you pass. So it really is a situation where you've got to look at, trying to figure out a way to either afford the insurance or make sure that you've transferred these assets before long time before, 5 years before you would need them.
Okay. We've got Myra on the line with a question from Fort Payne. Hi, Myra. Thanks for calling. What's your question tonight?
Hey, my question is that my husband passed away 4 years ago, and so I immediately put my adult children's names on the title to my home.
Okay.
I'm contemplating selling my home and buying another one. So do I have to start the 5 years over again? Because I'm only 1 year away from that being, not an issue with a nursing home.
Interesting.
And that type of thing.
Yeah, it is kind of interesting. It doesn't sound like you're probably looking at long-term care in any kind of immediate situation. But if you transfer an asset, what they're going to look at is whether that asset was transferred for value at the time that you made the transfer. So if it's if you transferred it 4 years ago, and you sell it, do your kids get the are they going to get the assets? If they've got it on right of survivorship, but are they going to get anything from the sale of the home? More than likely, if they don't, then you're really looking at the value of that asset at the time that you sell it, and they're going to look back at that for 5 years.
They're telling us take a break. We're going to take a break, but we're going to come back and talk about, arbitration and some of the contracts that you sign when you're dealing with nursing homes. We'll also talk about what kind of insurance they have in case your loved one gets hurt. Do they have insurance? We'll be right back. 31 Law Call, Grandpa in the Law.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Michael Timberlake's here from Timberlake, League & Brooks. We had a caller calling in asking, we're talking about grandpa in the law, we're talking about elder rights, wills, estates, trusts, all those kind of issues. And a caller wants to know if an elderly person signed a contract, could they get out of the contract saying that perhaps they didn't understand it, they weren't lucid, that kind of thing? A minor can not be held to a contract necessarily.
Yeah,
what do you think
absolutely.
with an elderly person with perhaps some mental deterioration?
Yeah, I mean, we see this issue come up all the time in terms of, arbitration agreements when somebody's admitted to an assisted living facility or a nursing home. Is that person that's being admitted, do they have the ability to contract for themselves and commit themselves to, either a payment term or a just a arbitration contract? And what the law will look at is they'll say, look, if this person understands what they're doing at the time they're doing it, and understands the gravity of what they're doing, and there's evidence to that effect, that they understood what they were doing at that time, then more than likely they're going to be held to be, bound by that contract. In order to hold someone, completely incapable, say that they're completely incapacitated from making any decisions or having any moments of lucid thought, that's a heavy burden. And a lot of times, unless somebody's been adjudicated incompetent by a court, or you have a doctor that will come in and say, yes, this person was completely incompetent, 24/7, unable to make any decisions at any point in time, then it's a very difficult thing to prove that they were, unable to contract.
We've got Betty on the line with a question from Rogersville. Hi, Betty. Thanks for calling. What's your question tonight?
I just wanted to ask a question about if you have a will it have to be probated at any time? And would a bond have to be set for anything?
Okay. If she passes away and there's a will,
that's
do
a good
you
question.
have to probate it?
Well, no. Typically, if all the heirs agree that there's no need to probate a will, then you don't have to probate a will. People talk about trying to avoid probate, and it's really nonsensical in a lot of measures. If you have a will, if you have property, get a will, designate who you want it to go to. If you don't need that will, then you don't have to probate that will. If a will does have to go through probate, most wills specify that so-and-such can serve without the necessity of a bond. So there's not, any kind of real, huge issue here. The bonds aren't expensive, even if you have to get them. They may be, depending upon the size of the estate, but a $20,000 estate can be $100. So it's really, that the bonds are very inexpensive. So you want to look at that situation and say, look, I want to make sure that my property goes to the people that I want it to go to. So get a will, and then you can designate beneficiaries outside of the will, and the will may not have to be probated, but at least you've got that backstop.
Let's talk some more about arbitration and contracts. We were just talking about elderly people and signing contracts. Nursing homes, typically, you deal with this a lot. Are they always going to make you sign something that agrees to an arbitration, or 90% of them?
99.9% of the time, what they're going to do is ask the person that's being admitted, and most of the time they're not capable or they're somewhere else, or their loved one, their family member, someone has a power of attorney to sign something that says, we don't want to, if there's any claims that arise out of this admission to this nursing home or a skilled nursing facility, we don't want to have to go present those to a jury. We're going to arbitrate those claims. That is definitely against the interests of the person that's admitted to the facility, their family, or anybody that may be injured. It's just different night and day type thing between what happens in a jury trial and then what happens in arbitration.
What's the difference? Why do I want to be able to have a jury trial?
Well, I mean, if you're sitting with a jury trial, then you're able to utilize the court system and the subpoena power, the discovery power, the power of being able to go present your case to a jury for the outcome of the case. None of that costs you money because it's a public service.
Right.
Now, arbitration costs both people money, and it's you have to pay to make a claim. The defense has to pay to make their defenses to a claim, and you're dealing with someone that's not 12 people that's in your community that would be able to judge your case. It would be one person that is typically a lawyer, maybe a retired judge that's resigned themselves to the fact that all they really want to do is to hear other people's disputes and make a decision about that late in their life. It really is just not a good, it doesn't provide you the same type of result you could with a jury.
Okay. We've got Alice on the line with a question from Hollywood. Hi, Alice. Thanks for calling. What's your question tonight?
Yes, my husband left me and our two sons in '84 for another woman. I got divorce papers in the mail, and it didn't have my signature on it, and it didn't have his signature on it. So are we divorced or not? Well, no, he's dead now anyway, but everybody's telling me y'all wasn't divorced if y'all didn't sign the divorce papers.
So it could depend on whether you got defaulted, if perhaps they served you with divorce papers and you never filed an answer. No, you don't think so?
No, I got the divorce papers that he took out. They were sent to me in the mail.
Okay. I would suggest that you go to your county courthouse and go look it up and see if there is something in there, because it makes me concerned that you've missed something. It doesn't sound like you would have been divorced, but you need to go check with your county courthouse and see if they can search your name and see if they've got something on record. Okay?
Yeah, I mean, unless a judgment of divorce is entered, or there's can be a default judgment when nobody answers, then nothing's official.
And they could have published in the newspaper, the old-fashioned newspaper.
Right,
they could have published service to you in the newspaper, and even though you never knew it happened, you didn't know anything about it, you could have defaulted. So you need to go check.
Right.
Okay?
And if that didn't happen, you're still his spouse at the time of death.
Let's talk a little bit about insurance, because I talked about that. You were telling me something that I was surprised about. Do nursing homes have to have insurance?
No.
How is it How is it possible that they're taking care of your loved ones, handling all of these people, and they don't have to have insurance?
So you have to have, in Alabama, to operate a motor vehicle, you have to have $25,000 of liability coverage. It's not enough, but at least it's something. If you're a medical provider, if you're a hospital, if you're a nursing home, if you're an ancillary care center, if you're assisted living facility or a long-term care facility, you're not mandated to have any amount of liability insurance coverage to cover the harms that you may cause. It's a huge problem and a huge issue that we face all the time. You end up with a facility that's handling, caring for older people that are in a very delicate situation, and they can cause great harm, but they're not required to have any kind of liability insurance that covers them for their harms.
We've got Brenda on the line with a question from Horton. Hi, Brenda. Thanks for calling. What's your question tonight?
Yes, I just have a quick question. If me and my husband make a will and one of us pass away, can the will be changed?
Well, yes, absolutely, because wills aren't, they're not a husband and wife will. They're a husband will and there's a wife will. And so basically you would, designate who your beneficiaries are. He would designate who his beneficiaries are. If he gives everything to you and you should predecease, then it would go to the people that you designate in your will. So if it's your children and you predecease, everything that you would get would go to your children, and which just according to your will. So that's kind of the way it works. There's some particular things if people die within a very short period of time together that can come into play. And all wills basically have a provision that says, look, if we die simultaneously, this person is dating, that we agree that this person died before I did for legal purposes, and that can designate how it all flows out. So any lawyer that handles a will can explain that to you.
Let's talk about powers of attorney,
right?
And what happens when the person dies. So what do you do with the power of attorney after somebody dies?
Yeah, a power of attorney is a great device, and basically it allows someone else to make all the decisions that you could make in your lifetime for you. They don't have to tell you about it, but so make sure that somebody you trust that you give power of attorney for. But really, it's one of those things that you need to have someone that's designated in case something to happen to you and you're not able to make decisions, and some decisions have to be made for the benefit of your heirs or the benefit of yourself in a timely and a quick manner. That way you don't have to go to court. You're not dealing with whether somebody's incompetent. You're not dealing with witnesses. You're not dealing with hearings. It's basically someone there steps in to your place at any given time. It's a pretty easy thing, but they only last while you're alive. Once you're gone, then your personal representative, whoever you designated in your will, steps in.
How do you qualify for long-term care insurance? Is that a problem? Is that a difficult thing to do?
Typically it is. Typically a lot of businesses have short. Are you talking about disability insurance or long-term care for nursing home?
Either one.
Okay, so you're dealing with long-term care insurance in a nursing home, and it's something that's really important that people need to understand. They need to go in. With their 50. You need to start talking to somebody about long-term care insurance. What's going to happen to the point where you're, 65, you have limited income, but Medicare is not going to pay for long-term care. You need to make sure that there's something out there to pay for the care that you need. And it can be in your home or it can be in a facility, but you need to have that insurance in place.
They're telling us to take a break. We'll be right back answering more of your questions about grandpa and the law. Stay with us. Here we go. If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake with Timberlake, League and Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon does a great job with all kinds of family law issues that we've been talking about tonight. 256-539-7337 or SharonFamilyLaw.com.
Thanks for your calls and questions tonight, and we'll see you next week.